Good afternoon, and welcome to the Environmental Law Institute. You have joined us for the basics of the Clean Water Act. My name is Caitlin McCarthy, and I'm the Director of Education, Associates, and Corporate Partnerships here at ELI. We are delighted to welcome everyone to ELI's annual Summer School Series, and I encourage you to join us here at ELI every Tuesday for Summer School. For more information, please see the event page of our website, eli.org. I will note that every summer school seminar will be taking place by webinar only this summer to ensure the safety of our panelists, participants, and staff. Thank you for your understanding and for joining us. At the end of today's panel, we will have time for a question and answer session. Please submit your questions through GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their expertise to summer school. I will introduce them briefly momentarily, but I would also encourage you to check out our website where you can find their bios hyperlinked and more of their expertise and experience in more detail. As we begin, I would like to briefly introduce our panelists. Abigail Andre is an adjunct professor at Stern College of Law at the University of Denver. She is a civil litigator who specializes in complex environmental matters. Prior to teaching, Abigail was a trial attorney for the Environment and Natural Resources Division of the Department of Justice. At the Justice Department, she led a diverse docket arising from violations of most federal environmental statutes and worked with many federal agencies, including the EPA, NOAA, the U.S. Coast Guard, and the Department of the Interior. Abby, we're delighted to have you with us today. Sara Colangelo is the Director of the Environmental Law and Policy Program at Georgetown University Law Center. She teaches 2 seminars in advanced environmental law at Georgetown. Professor Colangelo is the recipient of the 2020 Fahey Teaching Award for Georgetown Law. Prior to joining Georgetown, she served as a trial attorney for 8 years at the Environment and Natural Resources Division of the Department of Justice in the Environmental Enforcement Section. Sara, we are glad to be welcoming you back as summer school faculty. Dr. Holly Doremus is the James H. House and Hiram H. Hurd Professor of Environmental Regulation, the co-director of the Law of the Sea Institute, and the co-faculty director of the Berkeley Institute for Parks, People, and Biodiversity at the University of California, Berkeley School of Law. She is the leading scholar and teacher in the areas of environmental law, natural resources law, and law and science. Holly brings a strong background in life sciences and a commitment to interdisciplinary teaching and scholarship to her work at Berkeley Law. She earned her PhD from Cornell University and was a postdoctoral associate at the University of Missouri before making the transition to law. Holly, we're thrilled to have you lending your expertise to summer school. And Laura Mona is the Assistant General Attorney, Environmental Legal for BNSF Railway Company. As the in-house Assistant General Attorney, she focuses her expertise in a range of environmental areas, including CERCLA, Phase 1 and 2 environmental site assessments, air compliance and permitting, state pollution discharge elimination system compliance and permitting, PBS and CBS compliance and permitting, State Environmental Quality Review Act issues, brownfields, due diligence, land use, litigation, and of course, the Clean Water Act. Previously, Laura worked in private practice. Laura, we're so happy to have you here with us today. With that, I will turn things over to Holly to get us started.
There we go. Thank you. Good morning, everybody. I guess it's afternoon if you're on the East Coast. Still morning for me here. Let's see. How do I get to this? There we go. I'm going to give an overview of the Clean Water Act, and then our other panelists will give more details about some currently important disputes and conflicts and questions. So I want to start a little bit with the history of water pollution regulation in the United States. Water pollution's been recognized as a serious issue since it became known that it was the cause of cholera, that insufficient treatment or care of sewage spread waterborne diseases. And in the 19th century, there were a bunch of cholera epidemics that led to recognition of water pollution as the cause and beginnings of public water treatment and sewer systems as a response. Industrial water pollution grew really rapidly in the first half and shortly thereafter of the 20th century after World War II. And by the 1960s, it was really apparent that industrial water pollution was a big problem. This is a picture of the Cuyahoga River in about 1969, just before a famous fire on the Cuyahoga River. You wouldn't think rivers are things that catch on fire, but indeed they did in the 1960s because there was oil, among other things, in the rivers. And that's one of the things that got our attention and sparked the Clean Water Act. This is a picture of an oil spill in Santa Barbara in 1969, another triggering event for realizing that water pollution was something that needed more serious control. The early legal responses were, technical difficulties for me. The early legal responses were first, of course, the common law, things like nuisance, which were available, but it was hard to prove the elements, particularly that what was going on was unreasonable. The federal government, there we go. Sorry, I'm having a little difficulties here. I don't know why I can't go backwards. Can I get a hand on this? Oh, there we go. Thank you. The Rivers and Harbors Act was passed in 1899, and it said that you couldn't have unpermitted discharge of refuse to navigable waters. Sounds like water pollution control, but it specifically exempted liquid refuse from sewers, and it was quite narrowly construed to only apply to things that interfered with navigation. States started adopting water quality standards or effluent limitations, but very piecemeal and only a few of them. In 1948, the federal government passed the Federal Water Pollution Control Act, which was basically about providing assistance to states that wanted to deal with their water pollution problems. In 1965, the feds got a little more aggressive, required states to adopt water quality standards, but water quality standards alone, as we'll talk about a little bit later, are quite difficult to enforce, largely because if you find a water quality problem, it's hard to know who to blame for that. Okay, in 1972, we finally got what is now known as the Clean Water Act, the modern law that we have, which imposed stringent new federal regulatory requirements. The Clean Water Act was actually vetoed by President Nixon because it handed out a bunch of money for infrastructure, for construction of publicly owned treatment works, and Nixon thought that wasn't a good idea, but Congress thought it really was a good idea, and there was enough support for that that they overrode the veto. I'm really having trouble with the slides here. The Clean Water Act takes a cooperative federalism approach, and it gives important roles to both the state and the federal governments. Federal law basically sets the regulatory floor, as is typical of cooperative federalism, but states can be more strict if they choose to be, and many, including my state of California, have chosen to do more than the feds do. So some key provisions of the Clean Water Act start with the goals and policy of the Act. Section 101 says the objective of this Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. So it's all about making the waters what they would be without human interference. And it set a number of aggressive goals. We were going to eliminate the discharge of pollutants to navigable waters by 1985. Oops, it's a little bit past 1985 now. We haven't quite done that. Achieving water quality sufficient to protect water recreation and aquatic life. We'll talk at the end about where we are there. And prohibiting the discharge of toxic pollutants in toxic amounts. Congress also said in the Clean Water Act that the states had a very important role. Indeed, it's the primary responsibility and right of states to prevent, reduce, and eliminate pollution. And it's expressly the policy of the Congress that states get to allocate water quantity and that that's not affected by the Clean Water Act. The Clean Water Act requires, as I said already, states some states at least had been setting water quality standards in 1965. They were told by federal law that they had to. The modern Clean Water Act continues that. States are to set water quality standards for waters within their borders. Those are subject to EPA review and approval, and they have to be revised periodically. And the water quality standards are supposed to protect public health or welfare, enhance the quality of water, and serve the purposes of the Clean Water Act. And what they do is they combine the designated uses of the water segment. Is it for recreation? Is it for habitat for fish? Those kinds of things. And all existing uses must be included. In other words, the states can't formally say, we're going to let our water get worse. Then they take those uses and they combine them with water quality criteria, which are basically how much of what pollutants are consistent with these uses. EPA helps out by supplying some reference criteria, but if the states have sufficient reason, they have some science behind it, they don't have to adopt EPA's criteria. Theoretically, if we take the uses and combine them with the criteria, that ought to produce numerical standards for how much of each pollutant can be in each water segment. But often the states don't have numbers to assign, and they just use what are called narrative standards, say things like, there won't be any substances in the water which will impart any undesirable taste to fish flesh or make fish inedible. That's an actual water quality standard from, I believe, Iowa. Water quality standards do a couple of things. One is that they give the states some power. Section 401 of the Clean Water Act says that the applicant for a federal permit or a license which may result in any discharge to navigable waters has to get certification from the state that the discharge won't violate state water quality standards. In other words, the feds can't approve these kinds of activities unless the states either say that's consistent with their water quality standards or waive that requirement. And that's been applicants have been complaining about that provision for quite some time. In addition to water quality standards, which, as I said earlier, are hard to enforce by themselves, the modern Clean Water Act includes point source discharge regulation. And that's, as you can see, a classic point source, a pipe dumping water with other substances into a waterway. The Clean Water Act basically says you can't discharge any pollutant unless you have a permit. And there are two kinds of permits under Section 402. They're the National Pollutant Discharge Elimination System. Remember, we were going to stop pollution to the waters by 1985. This is the system for doing it, and it's basically the industrial pollution regulation system. Under Section 404, there's a separate permitting program run by the Army Corps of Engineers for discharges to wetlands, discharges of dredged and fill material. The Section 402 program is usually considered the heart of the Clean Water Act. It's implemented largely by the states. States are delegated authority by EPA to run this program. And this slide is the 2019 version. It's showing you only the states like New Mexico there that look really pale. Those are the only ones that don't have any authority to do NPDES permitting. The permits have to contain certain terms. They have to contain technology-based effluent limitations. Those are set on a categorical basis by EPA, and they require application of best available technology. They can set zero discharge standards. If there's not an EPA categorical standard, then the permit writer, who is often a state official, applies his or her best professional judgment. Technology-based standards are about leveling the industrial playing field. They're so that everybody in a particular industry has to control their pollution wherever their plant is located throughout the country. But they don't differentiate on the basis of the quality of receiving waters or how many other sources are there. So they don't by themselves ensure compliance with water quality standards. So the permits also are supposed to include additional restrictions if needed to ensure that compliance. And there's a program called Total Maximum Daily Loads, TMDLs, which is about translating water quality standards into effluent limitation standards on individual sources. States are required to identify their impaired waters, waters that won't meet water quality standards on the basis of technology-based limitations. And for each of those waters, they set a pollution budget, how much of what substances can go into these waters consistent with meeting the water quality standards. And then they divide that up. The states get to decide how much of that budget goes to which source, and they're supposed to account not just for point sources, but also for non-point sources. So there are a number of enduring challenges under the Clean Water Act. One is just defining the scope of the 402 permit program, what waters are covered and what actions require permits. Another is dealing with non-point source pollution, which is largely left to the states and has not yet been effectively controlled. And finally, achieving the water quality that is our goal. Unless we effectively implement both the point source and some non-point source regulation, we won't get to acceptable water quality. So I want to talk a bit first about the scope of the point source program, because that's been the source of a lot of controversy and litigation. I already pointed out that the Clean Water Act says that if you want to discharge a pollutant, you need a permit. It defines discharge of a pollutant to mean any addition of any pollutant to navigable waters from any point source. And all four of those terms have proven rather difficult to understand. Taking them in order, we'll start with what's the addition of a pollutant to a navigable water? Well, there's not a statutory definition of addition. It sounds pretty straightforward, but it turns out it's not. The Supreme Court case that addressed it is called South Florida Water Management District versus Miccosukee Tribe of Indians. And the question there was whether this pump station in the Everglades, which was part of a Corps of Engineers water project there, required a permit. The pump station takes water from canals, puts it in an Everglades wetland. Rainwater runs off into the canals, and the rainwater contains phosphorus fertilizer. That's a problem in the Everglades because it encourages the growth of algae and non-native plants. The Supreme Court said that whether those pumps require a permit depends on whether they're adding a pollutant to the Everglades, and that depends on whether they're moving it from one water body to another, whether the canals are a distinct water body from the wetland that they're putting the water, that the pumps are putting the water into. That left things quite unclear, but EPA then adopted what it calls the Water Transfers Rule, which says that you don't need a permit for transfers that convey or connect waters of the United States, as long as that transfer is not introducing pollutants to the water transfer. So EPA said those pumps don't require a permit. Why does the Water Transfers Rule matter? Well, these are pictures of a couple of water bodies near me. Clear Lake is a naturally eutrophic lake. It's ridiculous that it's called Clear Lake. If you drive by and look at it, it's utterly green, as you can see in this picture, because there's a lot of algae growing, because there are a lot of nutrients. Not far away is Lake Tahoe, which is famously one of the bluest waters in the country. And if you took a bunch of water from Clear Lake, transferred it to Lake Tahoe, you would certainly change the water quality in Lake Tahoe. Nonetheless, EPA's rule saying you don't need a Clean Water Act permit to make that kind of transfer has now been upheld by two different circuits. And the bottom line of that is that those S9 pumps don't need a permit because they're only engaged in transferring water, even if they are creating water quality problems for the Everglades. What's a pollutant? Well, there's a very broad definition of that in the statute. It includes pretty much any kind of waste, biological materials, heat, rock, etc., etc. It's usually pretty obvious that something is or is not, well, is a pollutant because that definition is so broad. One place this has been a source of controversy is with respect to pesticides. This is aerial pesticide spraying of a potato field. And if there's a waterway in or near that area, some of those pesticides are going to get into it. Turns out the Sixth Circuit said in 2009, yes, that requires a Clean Water Act permit. Now, permits can be issued in a general, on general terms, and that's what EPA has done. I think we'll hear a little more about general permits later. What are navigable waters? This has been incredibly difficult to figure out. The statute says navigable waters means the waters of the United States, which sounds pretty simple, but turns out it's anything but. The Supreme Court has had to deal with this question 3 times. Most recently, they really didn't come up with an answer. There were 4 justices led by Justice Scalia who said, well, it has to be a stream with relatively continuous flow, or at least seasonal flow. Justice Kennedy said, well, as long as it has a significant nexus with traditionally navigable waters, it can be regulated. And 4 of the other justices said it's whatever EPA says it is, which is broader than the waterway at issue here. Here's just an illustration to show why this matters. You can have these isolated wetlands. You can have streams that flow continuously. You can have streams that flow seasonally. You can have streams that only flow after a storm event. Post Rapanos, EPA sort of sat on its hands for quite a while, although several justices had said you shouldn't. Eventually, in the Obama administration, they issued what's called the Clean Water Rule, which sought to implement the significant nexus test. And the Obama administration said that will increase federal jurisdictional waters, the scope, by about 3%. People opposed to the rule thought there would be a much larger increase. It was never implemented, the Clean Waters Rule, because it was stayed nationwide. Turns out, according to the Supreme Court, that has to be litigated district by district. And so then there's been this giant mess about what rule applies in what part of the country. Now, just in April, the Trump administration has finalized its own rule, which it calls the Navigable Waters Protection Test. And it does away, it does away with Kennedy's significant nexus test and excludes ephemeral streams from federal jurisdiction, excludes wetlands that don't have a direct surface connection with navigable waters. So whereas the Obama rule would have expanded federal jurisdiction some, the Trump rule contracts federal jurisdiction to some extent. Although again, it's not really clear how much of an effect that will be. This is a map showing that a lot of streams are intermittent, especially in the West. And there are real concerns in the West in particular that jurisdiction will be contracted a great deal by the Trump rule. And here's an example. This is the LA River where it's channelized. This is an example of a river. You can see people floating down it. They did that to show that it was navigable, but it does only flow after big rainstorms. And it might not be a federal jurisdictional waterway anymore after the Trump rule. This is a vernal pool in California, which is an isolated wetlands without a surface, probably without a surface connection to navigable waters, and also perhaps now outside of federal jurisdiction. The real lesson from all of this is that both the Trump administration and the Obama administration have said their rulemakings about waters of the United States would clarify things. I think that's actually not true for either of them, but it's certainly unclear now. The Trump rule is going to be litigated, and it's going to have to be litigated district by district. We're not going to know for a long time where federal jurisdiction exists. Finally, what's a point source? That's a discernible, confined, and discrete conveyance, including pipes and other such things. That, too, you might think was clear, but it's definitely not. Here are some pictures of things where there's been litigation about whether it's a point source. A shooting range, where people are out shooting targets. Lead bullets fall into waterways. Is that a point source? The mothball fleet in San Francisco Bay, a bunch of old World War II ships with things falling off them in not in the ocean, but in inside San Francisco Bay. Is that a point source? Coal ash ponds, that's been an issue lately. And then chicken coops, internal chicken coops where the ventilation system sends some manure and litter outside where it can wash into streams. It turns out it's very difficult to determine what is a point source and what's not, where the line is. It makes a huge difference because point sources are federally regulated, require federal permits. Non-point sources are not federally regulated. It's entirely up to states what to do. And there may be some principles we can think about, including what's the balance of federal-state authority, what should it be, were we supposed to be thinking about only industrial sources? Really, how to draw these lines remains very unclear. So have we controlled non-point source pollution, and how well? Well, we've left it up to states. Some do more than others. This is just to show that not much has changed over the past 25 years. This is a fact sheet from EPA in 1996, basically saying non-point source pollution is now the nation's largest water quality problem because since 1972, we've been controlling point source pollution. Maybe not as effectively as everybody thinks we should, but there at least are permitting requirements. And this is from 2020. EPA's website currently says, states report that non-point source pollution is the leading remaining cause of water quality problems. So in the 24 years since 1996, we've done very little actually about non-point source pollution. And we haven't achieved the water quality standards. This is from the most recent EPA report. Actually, one of the issues about water quality standards is that we don't have nearly as much data as we would like to have. And we still haven't assessed a lot of our waterways, and we don't assess them regularly. So this data is actually from a report in 2008 to 2009, but it's a biological condition of the nation's rivers and streams. And just looking at those pie charts, red is bad, as you might guess. And there's an awful lot of red. An awful lot of our rivers and streams are not meeting water quality standards for biological condition. So I want to leave you with 3 messages before we hear more details. We've done a lot since 1972 to reduce point source industrial pollution. We've done a lot less to control non-point source pollution, and we've still not really sorted out what our point source program exactly governs and how, and that remains hotly contested. It's important economically to the sources, and it determines the balance of state and federal power. And I'll stop there and let our real experts have the floor.
Hi, good morning, everyone. I'm Abigail Andre. Thanks, Professor Dorimus, for that great foundation. So we're going to talk about a couple of discrete issues first. Implementation of the Act and enforcement of the Act. So these topics could cover semesters worth of material. So I've tried to choose a couple of narrow examples to help illustrate some basic concepts. Because our next 2 presenters will be talking about Empties permitting in more detail, I'm going to focus on some different examples from the Act. So first, I'll discuss Clean Water Act implementation through regulations and by explaining the process by which federal and state agencies write rules very briefly, and then walk through regulations defining one type of point source. Then I will discuss the basic avenues of Clean Water Act enforcement and walk through judicial application of Section 311, which governs oil spills. And for that, I'll apply the law to the facts of the Deepwater Horizon oil spill case. Okay, so how is the Clean Water Act implemented? We're going to take a brief detour into administrative law to answer that question. So federal agencies, including the EPA, are housed, generally speaking, in the executive branch, and they're imbued with the power to govern on specific topics. So they're controlled by their own regulations and other federal statutes passed to dictate agency behavior. So why are we talking about administrative law? As you might already know from our first presentation, the vast majority of federal environmental law is regulatory, and a handful of federal agencies implement and enforce environmental regulations. So states have their own agencies and must create programs that are as protective, generally speaking, as federal standards. So you start with the Clean Water Act, which is broad and delegates Congress's lawmaking authority to federal agencies and states. It does that with something called a legislative mandate, which directly or indirectly gives agencies power to write and enforce laws that implement the statute. And I've included here one of the legislative mandates that you'll find in the Clean Water Act, which basically says, unless the statute says otherwise, implementation and enforcement of the act is left up to the EPA. So the scopes of congressional mandates and therefore agency power, the validity of the procedures and rules the agency use are often hotly contested. And I mention that to highlight that while the text of the Clean Water Act itself is rarely amended, underlying regulations do change all the time. So the study of environmental law is necessarily bound up with administrative law, and perhaps now more so than ever. A recent New York Times article lists almost 100 regulations that the Trump administration has rolled back since 2016 in the environmental arena alone. So once power is delegated to an agency, the agency or state agency fills in the details that the Clean Water Act doesn't speak to. They do that with procedural rules and with substantive rules. So some examples of substantive regulations include Waters of the United States, which we already talked about some, and we'll talk more about later today. Regulations pertaining to animal feedlots that trigger which facilities become a point source and therefore need a permit. And then the last two examples here that I've listed are pertaining to oil spill regulation. The Sheen rule defines what quantity of oil must be spilt to trigger the act, and the quantity is actually quite low. It's based on a visual test. I've also listed some safety regulations that agencies housed within the Department of Interior wrote to control or help increase the safety of deepwater drilling. So we have regulations that directly impact how environmental law is implemented. And then we also have regulations which are meant to support the purpose of the act by helping to control pollution. It's important to realize that agencies make far more law than Congress, and administrative adjudication, which includes procedures for responding to regulatory violations within an agency, that creates far more law than federal courts. So let's dig a little deeper into one of these examples, and that's with concentrated animal feeding operations. So our example here is to illustrate one trigger for Empties permitting under the Clean Water Act and give you a sense for the complexity of environmental regulation. So regulations can feel a bit like a math problem. You have a series of related steps that all add up to an answer to a question. In this example, the question is, does my 2,000 head cattle feedlot need to obtain a Empties permit? Now, to answer this question, you need more information, but the problem is just looking at the act won't get you there. It's broad, in some cases vague, and oftentimes has holes that mean that you don't know what the answer to your question is based on the statute alone. So looking at the statute, we do know that concentrated animal feeding operations is included in the definition of a point source. And we know that if your feedlot is concentrated, it probably needs a Empties permit to cover the discharges of waste from the feedlot. Lastly, we know from the Act that it doesn't define CAFO or AFO or any other term that really helps answer this question. So you turn to the regulations. And I've included federal regulations here, but you should always keep in mind that there might be state regulations that impact your facility. So this is meant to illustrate the steps that you might need to take, the sheer number of steps that you might need to take to answer questions specific to implementation of the Clean Water Act. So you start with the statute, and sometimes your inquiry ends there, but not always. When you identify silence or ambiguity or still have questions, you turn to other sources. And in this case, you turn to regulations. Their federal regulations are found in the Codified Federal Register, the CFR, and CAFO regs are at section 122.23. So walking through that statute, or that regulation rather, section B1 defines what an animal feeding operation is. It's its broadest term used by the regulation that covers pretty much anything that you'd think of as a feedlot. It includes animal feeding operations where animals are kept for at least 45 days and crops aren't grown, generally. Section B2 defines when an AFO becomes a CAFO based generally on size and waste management practices. Finally, Section C grants authority for some states and the EPA regional administrators to designate AFOs as CAFOs even if they don't meet the requirements of B2. So the regulations tell us that large CAFOs are categorized as CAFOs and therefore a point source because they house a large number of animals. And the regulation has a long list of animals and head count that you can look at to decide whether or not you might be a large CAFO. Specifically, any animal feeding operation with more than 1,000 head of cattle is a large CAFO. The regulations also tell us that an animal feeding operation is a CAFO when it houses a medium number of animals as prescribed by the Act, by the regulations, and it meets a method of discharge criteria. Finally, even if an AFO doesn't meet the definition of large or medium CAFO, but is nonetheless a major source of pollution, it might be designated as such by the permitting authority. So our farmer with the 2,000 head of cattle can look at these regulations and know that based on his head count, he probably needs an Empties permit. And that's setting aside other sources of information like state regulations and any controlling precedent interpreting these regulations that might move the ball a little bit. So regulations can be a little bit dizzying, but it's a great example of why regulated entities and those working with regulated entities and industries must be comfortable with them. And if you're a student, it might be a very good idea to take admin law to try to get a better grasp on how regulations are made and how law is made through the administrative process. So that was a very fast overview of administrative law and how it intersects with the Clean Water Act. I want to move on now to spend the rest of our time talking about enforcement. So the Clean Water Act has a variety of enforcement mechanisms. Some are implemented via regulation, and others explicitly are provided by the statute. So first, the statute and through regulation, the agencies are provided with lots of investigatory tools. So they become aware of possible violations through a variety of Tools including inspections, surprise and schedules, water quality monitoring and reporting. And generally speaking, state and federal agencies use these tools to work up and refer cases to their agency counsel and sometimes to the Department of Justice or state attorney general's offices. Perhaps the most important language from the statute to understand the scope of enforcement is that it's a strict liability statute in civil cases, which means proof of intent is not required to establish a violation. The fact of discharge and satisfaction of the other elements is sufficient. The exception to this is that intent is relevant in some criminal cases. So state and federal agencies both enforce the Clean Water Act through administrative procedures and adjudication, as well as judicial action. While you're probably somewhat familiar with judicial actions and criminal proceedings, civil administrative actions are extremely common. So those are actions, enforcement actions that occur inside the agency, either at a federal level or a state level. They're non-judicial and instigated again by usually EPA or the state if it's been given the authority to control that kind of case. So these actions do not involve judges and courts. An administrative action could include a notice of violation, a formal or informal trial or hearing, and often results in what's called an administrative order, which can include penalties or not, and remedies that we'll talk about in a couple of minutes. So these types of enforcement actions are controlled by regulations and fall under the auspices of administrative adjudication. Note that civil judicial actions are generally brought by the US Department of Justice on behalf of federal agencies and states attorney general on behalf of states. Criminal proceedings are rare, but they do happen. And as I already mentioned, the big difference between criminal and civil proceedings is that proof of intent is often required. So the two primary sections of the Clean Water Act that control enforcement are sections 309 and 311. 309 is EPA's primary enforcement mechanism. It includes sections for compliance and penalty orders for violations of some of the sections we've already talked about, including Section 301's prohibition against unpermitted discharges and requirements for permits under 401 and 402. It also allows for judicial actions and discusses criminal violations of a broad swath of Clean Water Act violations, including those impacting concentrated animal feeding operations. Section 311, which we haven't discussed yet today, covers oil spills and the spills of other types of hazardous substances. So that section is almost like its own little act within an act. It allows for cleanup and removal of oil and hazardous substances from waters of the US, adjoining shorelines, and other specified areas. It delegates the president with the authority to respond to spills, which in turn has been delegated to agencies who have the power to remove pollutants discharged and mitigate substantial threat of discharge. And like 309, Section 311 also has enforcement provisions, and it has actually very stringent reporting requirements. The Act is also enforced using citizen suits, which briefly allows citizens to file civil actions against the government in some cases. And I just wanted to mention remedies quickly here. These are the most common remedies that you'll see as a result of an enforcement action. You're probably familiar with some of these. Civil and criminal penalties are available in most cases, though they're not always imposed. Settlements are the most common remedy to an enforcement action, and they're agreed upon resolutions to an enforcement case. They can be administrative or judicial. Now, injunctive relief, mitigation, and supplemental environmental projects are all things that are aimed at either bringing the company into compliance and keeping the violator in compliance, and those are required and tend to be packaged as injunctive relief. But mitigation and supplemental environmental projects also try to be forward-looking about remedying the harm that was done by a violation. Sometimes those are required, sometimes they are not, but they are all packaged up as part of settlements in both administrative settlements and judicial settlements. And in some cases, incarceration is an available remedy, usually for criminal violations, but actually in the context of Section 311, there can be jail time if you fail to alert federal authorities that a spill has occurred. So for the remainder of our time, I want to introduce you to Section 311 in a civil judicial setting. There are three major steps in an oil spill trial under the Clean Water Act that you typically see. Liability and degree of fault are assessed kind of as one, and we'll discuss why. Quantification, which is how big the spill is. And finally, penalty calculation. Now, I've selected 311 to introduce you to another liability standard, but you should note that this third step, penalty calculation, is governed by a set of factors that's also found in Section 309 and also often considered as part of administrative settlements. So as our example today, we're going to talk about the Deepwater oil spill case, which I worked on when I was at DOJ. It was a spill in 2010 in the Gulf of Mexico, which probably most of you are familiar with. But to summarize a few key facts, it was the largest environmental disaster in US history, and it resulted in one of the largest environmental civil enforcements and litigations in history. The case was consolidated into what's called a multi-district litigation, which took all kinds of claims, including the United States Clean Water Act claims, but private claims, business losses, personal injury, other state-based economic loss claims, torts. It combined all of these under the roof of the Eastern District of Louisiana. And Judge Barbier of the Eastern District presided over all of them. And some of these cases continue today, are still ongoing. But for today's purposes, obviously, we'll focus on the Clean Water Act claims. So we had 3 civil trials over about 5 years, which in the land of civil litigation is incredibly fast. And facts that are most well-known and highly relevant to the case is that there was loss of life. 11 men died the day the spill started with a large blowout on the Deepwater Horizon rig. Millions of barrels of oil were spilled over 87 days, and there were massive environmental and economic losses for the Gulf region. Parties for the United States, or for the Clean Water Act claims, included the United States, but also the 5 Gulf states impacted: Alabama, Florida, Louisiana, Mississippi, and Texas. The defendants to the Clean Water Act claims included the leaseholders. And when I say leaseholders, what I mean is those entities who had leased from the federal government the land under the well where they hoped to find oil. So it was Mississippi Block 252, and BP and its co-lessees, Moex and Anadarko, held the lease on the land and rights to the oil that they may have extracted from it. Transocean was also named by the Clean Water Act claims because it owned the rig, Deepwater Horizon, and provided the crew. There were other contractors involved in the case, but none of them were parties. So let's apply step 1 to the facts of this case. So liability under Section 311 has 5 elements. It's triggered when an owner, operator, or person in charge of a vessel, facility of one type, either onshore or offshore, has oil discharged from it into waters of the United States in a quantity that might be harmful. So those are 5 steps, but relatively straightforward facts. The terms in the first two bullets largely are defined by the statute and have relatively intuitive meanings. Regulations define waters of the United States and quantities which might be harmful. As I already mentioned, that's covered by the EPA's Sheen rule. So these 5 separate elements of liability were easily applied to the facts of Deepwater Horizon as they pertained to BP. In fact, BP's liability was actually established on summary judgment. BP was an owner of the lease and therefore the well. It was found to be in charge of the rig, even though it didn't own the rig. The rig was what's typically thought of as an offshore oil facility. It was a MODU, motor-operated drilling unit. And the last two were relatively straightforward. Oil was discharged from the well, it was discharged from the rig, and clearly into waters of the United States, because the Gulf of Mexico is inarguably that. And the amount discharged obviously was also satisfied by the Sheen rule, which only requires a visible sheen of oil on the water surface to trigger liability. So as you see, none of these elements require intent, but a common part of liability inquiry for Section 311 assesses violators' degree of fault because it multiplies possible penalties under the Act. So baked into the first step of a Section 311 liability case is assessment of the degree of fault involved, particularly the degree of fault involved with the discharge itself. Under Section 311, the stakes are much, much higher if the discharge was the result of bad acts. So looking at these penalty rules, you should note 2 things. First, the word shall appears in both paragraphs. Courts have construed this to mean that penalties are required when there is violation of Section 311 cases. Second is that there are 2 different penalty amounts per barrel based on the degree of fault of the violator. When gross negligence or willful misconduct causes a discharge, the amount of penalty is substantially increased. So regulations have increased these numbers. At the time of the spill, the first category was $1,100 per barrel. The second category was $4,300 per barrel. Now it's almost $1,900 and $5,700 respectively. So gross negligence and willful misconduct are not defined by the Act, and therefore the court had to look to common law to decide what those terms meant. And that's a common practice when there is silence in the statute and silence in the regulations. Gross negligence is defined by Judge Barbier in the Eastern District of Louisiana as an extreme departure from the care required under the circumstances or a failure to exercise even the slightest care. Willful misconduct is an act or omission with reckless disregard of probable consequences. Now, these are nuanced definitions, and there was a lot of briefing and argument about what these terms should mean, but basically those are the rules that the court applied. And I wanted to mention that because I think the most important thing of highest precedential value to come from the penalty ruling of this case was that the court decided that you could find gross negligence not only based on a single act that satisfied that extreme departure standard, but based on a series of merely negligent acts, which means moving forward that courts need not find an extreme departure of care to impose a higher per barrel penalty under the Act. Step 2 is straightforward, and I'll cover it quickly. The court has to find out how many barrels of oil were discharged. In cases of vessel spills, this can be relatively straightforward. They know how big the hull is, they know how much oil the hull was carrying. But in cases of spills from reservoir of unknown amount, there are endless technical questions. So this phase of trial was really down to a battle of the experts. And you'll see in the holding that the court found 2 different numbers for total amount discharged. the total amount discharged from the well was 4 million barrels. But then through efforts by BP and unified efforts from other federal agencies, some of that oil was collected. So the amount considered discharged to the environment and therefore available for penalty was 3.19 million barrels, a staggering amount. So step 3 of a typical Section 311 litigation is penalty calculation. And as I stated earlier, many of these considerations apply to Section 309 and administrative penalties also. Courts tend to first calculate the maximum allowable penalty under the Act. And they do that by taking the per barrel penalty from the degree of fault analysis in a spill like this. We're looking at barrels of oil spilled. And you multiply that times the number of barrels. So in Deepwater, it was 3.19 million barrels times $4,300 per barrel. That set the maximum penalty at roughly $14 billion, which would have been divided across the 3 leaseholders appropriate with their leasehold interest. Once you have that number, courts apply penalty factors, and they tend to do this in one of 2 ways, neither of which is required by the statute. Top down starts with the statutory maximum and decreases that number based on application of the penalty factors as appropriate. The bottoms up method starts with a number called economic benefit, which we'll discuss on the next slide, and adds penalty to it based on what the other factors prove. As I said, there's no consistent approach to this, so you'll always have to check with the district in which you are practicing to see what the preferred method is. So there are 8 penalty factors, and I'll just click them all on here so you can see them. We're not going to have time to talk about, oopsie daisy. Oh dear, I've accidentally clicked out of the presentation. I got it. Okay. I got it. Okay. So, penalty factors courts shall consider. Let's not do that again. Seriousness includes the evidence of human health, economic, and environmental harm. Some courts consider potential harm and actual harm. Culpability and other penalties for the same incident are straightforward. History of prior violations tend to include Clean Water Act violations, but can include other statutes. Efforts to mitigate the spill, cleanup efforts, impact of the penalty on the violator asks if the impact will be ruinous. Very quickly, courts must consider all 8 factors, and they perform a kind of totality of the circumstances application. There is no strict way how these have to be applied except for economic benefit. Economic benefit is basically trying to make sure that defendants don't economically benefit from costs that they avoided or profit that they gained that could have contributed to the violation. So avoided maintenance cost, avoided capital expenditures, things like that. It's a number that the Citgo case in the 5th Circuit requires courts to consider. So the penalty calculation I've left here is for Anadarko because before this ruling came out, BP settled with the United States for roughly $20 billion, which covered $5 billion for Clean Water Act claims and more than $8 billion for natural resources, among other costs. Anadarko's total penalty was $3.5 billion as a maximum. However, in applying the seriousness factor, economic benefit factor, and culpability factor, that number changed. Under seriousness, it was maxed out. Under economic benefit, the court found that it was not a useful number. It was too low under the circumstances. But finally, the court found that the company had not been culpable in the spill and therefore dramatically decreased its penalty. So I've run a bit over my time and I'm going to pass it off here to Professor Colangelo. But thank you for your time, and I hope you have a little better understanding of Clean Water Act enforcement and Clean Water Act implementation.
Okay, great, thank you. All right, let's see if I have control now over the PowerPoint. There we go. Thank you, everyone. Thank you to the Environmental Law Institute for having me back this summer to speak during summer school again. And I look forward to today talking about the County of Maui versus Hawaii Wildlife Fund case. We're devoting a section of this presentation to this particular case because it's our first Clean Water Act case in more than a decade. And it was just decided 7 weeks ago. So for environmental law attorneys, this is exciting stuff for us. So we're going to be spending some time with this today. During this presentation, I'm hoping to pull together some threads raised by Professors Doremus and Andre, because this case raises both a discrete jurisdictional question and some of the more thematic issues that you heard mentioned before in terms of that federal and state interplay over water resources. So we are going to speak, let's go right into the background of the case here. So today we're going to be talking about the County of Maui's Lahaina wastewater reclamation plant. And that plant collects sewage, partially treats it, and injects it into wells that are hundreds of feet underground. That effluent travels about half a mile and then emerges from submarine fissures in the Pacific Ocean. And it's been operational since the 1980s. And during this entire time, this plant has been conveying excess nutrients and pathogens to a popular coral reef snorkeling spot called Kakili Beach, which is quite beautiful. If you Google the best snorkeling spots on Maui, this is going to come up. So it is a treasure among the local community. And here, the legal dispute concerned whether the pollutant's journey through groundwater before reaching the ocean exempted the county's plant from federal permitting requirements under the Act. So recall from Professor Doremus that the Clean Water Act requires point sources of pollution to secure a NPDES permit for any addition of any pollutant to navigable waters. And the County of Maui case actually presented a very rare scenario for the court because everyone agreed here that the wells qualified as point sources and that the pollution reached navigable waters. So this is quite a different posture from the cases that you heard about earlier addressing waters of the United States, the Rapanos, Riverside Bayview, and Swank line of cases, which Professor Doremus rightly highlighted as generating a lot of the controversy and litigation around the scope of the Clean Water Act. So this is a different set of circumstances that we find ourselves in with the County of Maui case. But here, the parties could not agree whether the county could do indirectly what it could not do directly under the Act, and that is discharge pollutants into the ocean without a permit. And after negotiations failed, local environmental groups sued under the citizen suit provision of the Clean Water Act, alleging that the county needed a NPDES permit. Now, we didn't touch too much on citizen enforcement of the Act already, but just to highlight, citizens are empowered under the Act to step into the shoes of attorneys general and enforce a violation of the Act. They can also sue EPA for non-discretionary duties as well. And of course here, we know that a NPDES permit, if the county were required to get a NPDES permit, that would of course mandate more stringent and more costly treatment standards for the county. So what happens when they go to court? Okay, so the lower court cases, we'll touch on those briefly. The District Court of Hawaii agreed with the citizen groups, finding that the discharge was functionally one into navigable waters because the pollutant's path to the ocean was clearly ascertainable. Hydrological evidence played a very substantial role in the decision. I think it's very, very probable it played greatly into the Supreme Court decision as well. But it was particularly powerful, I think, at the lower court level. And I think that that's one of the key takeaways environmental attorneys should glean from this case. Here we had geochemists at the University of Hawaii, Manoa, who examined seaweed for nitrogen isotopes correlated to anthropogenic sources. They had outfitted drones with infrared lenses to detect plumes of abnormally warm water rising over those discharge points in the ocean. And the coral itself showed obvious degradation during the plant's operation. And they also documented that aquatic life and diversity had declined. And this is a very powerful image from Earth Justice, who led the citizen groups in the legal battle. I also want to highlight for you the dye tracer study that was conducted here, proving more than 60% of the effluent from the wells emerged into the reef. And this is important because this type of evidence is actually very rare in a Clean Water Act case. For those of you who practice under the Act, you know this. It's actually rare to have evidence demonstrating discrete environmental harm from a particular violation. Now, of course, environmental harm isn't necessary to prove a violation of the Act. It is relevant for the penalty stage, as was mentioned by Professor Andre, but it does help from an optics perspective whenever you're standing in front of a judge, if you can show a pretty visually compelling image like the ones that I've shown in this presentation. All right, so the Ninth Circuit affirmed the District of Hawaii's decision, but devised its own test, devised a novel test, holding that permits are required when pollutants are fairly traceable from a point source to navigable waters. Now, under President Obama, the Environmental Protection Agency sided with environmentalists and advanced the agency's decades-long position that Clean Water Act permitting requirements do apply to groundwater discharges with a direct hydrological connection to surface waters. And that 2018 Ninth Circuit decision contributed to a circuit split over whether a NPDES permit is required when pollutants are conveyed from a point source indirectly to navigable waters, meaning in this case through groundwater. The Fourth Circuit has held that a NPDES permit is required for discharges to groundwater with a direct hydrological connection to a point source, so they adopted EPA's longstanding position. But the Sixth Circuit had held that a NPDES permit would never be required for discharges to groundwater. And we know what happens when there's a circuit split like this. We're gonna get cert granted in the Supreme Court. And I think looking back now, it's very interesting that out of these cases raising this legal question, the court granted cert on the Maui case of all of them. So let's talk about the Supreme Court's decision. So the court ruled that a NPDES permit is required if the addition of pollutants through groundwater is the functional equivalent of a direct release into navigable waters from a point source. Justice Breyer's opinion garnered votes from Chief Justice Roberts and Justices Ginsburg, Sotomayor, Kagan, and Kavanaugh. And in crafting the functional equivalent test, the court rejected the legal positions of both the petitioner County of Maui and the respondent environmental groups as too extreme. And if you go back and listen to the oral argument with everyone's free time to listen to Supreme Court oral arguments, you don't have to read tea leaves to know the justices were left pretty unsatisfied and would be uncomfortable adopting the limiting principles proposed by the advocates. The court found the Ninth Circuit's fairly traceable test was too broad, sweeping in examples Congress could never have intended, they said, including pollutants carried on a bird's wing. So too, the more narrowly tailored position of respondents before the Supreme Court. So the environmental groups actually did try to narrow the applicability of the Ninth Circuit's test, and they offered that a permit was necessary whenever any pollutants actually and foreseeably reach navigable surface waters. And they tried to suggest the tort concept of proximate cause as a limiting principle, but the court still declined that proposal as well. And in a nod to federalism concerns, the court observed that the structure of the Clean Water Act indicates that as to groundwater pollution and non-point source pollution, Congress intended to leave substantial responsibility and autonomy to the states. But as I mentioned, the court also rejected County of Maui and found that that test that they offered was too narrow. The point source is the final conveyance of pollution to navigable waters. Oh, and it looks like I'm getting a message that I'm maybe having some network difficulties. Are people able to still hear me?
Yes.
Okay, I see my counterparts nodding. Okay, great, thank you. Okay, so the county proffered a means of delivery test under which a NPDES permit. Oh, now my screen is frozen. Okay, we're going to try to go back if possible. And Caitlin, could I have a little assistance going back a few slides if possible? Back one more, please. One more, sorry.
No problem.
Thank you so much. Okay, so as I mentioned, the county proffered means of delivery test under which a NPDES permit is necessary only when a point source is the final conveyance of pollution to navigable waters. And by that they meant if there was any intervening media, no matter how brief in space or time, the discharge was exempt. Now, the Trump administration filed a brief in support of Maui County. It adopted a new position, so you'll note this was an about face from the position that EPA had adopted for decades. And this new position was that discharges to groundwater are excluded from NPDES permitting. And that was expressed in a 2019 EPA interpretive statement. But the court dismissed that as a roadmap for evasion of the act, violating its protectionist purpose. And we have some pretty strong language from the court on this. And they say we do not see how Congress could have intended to create such a large and obvious loophole in one of the key regulatory innovations of the Clean Water Act. Professor Doremus referenced this section of the act really is the heart of the Clean Water Act, the NPDES permitting program, and she's absolutely right. That's how most people conceive of this portion of the act. And so under the county's approach, Justice Breyer points out the obvious, that a discharger could simply move the pipe back a few yards so that the pollution must travel through at least some groundwater before reaching the sea, and that was just untenable for the justices here. Okay, so after spurning these proposed tests from the petitioner and respondent, Justice Breyer has to craft his own. So he focuses on the preposition from and its object to in the statutory text and asks, was the discharge to surface water from a point source, from groundwater, or from both? And to answer this question, he explores everyday usage scenarios from travelers to meat drippings in a pan. At oral argument, the examples even included whiskey spiked punch and spirited debate over whether the whiskey was from the flask or was from Scotland. So it was about as amusing as an oral argument can get. So very interesting debate there. But that linguistic analysis paired with consideration of statutory purpose and statutory structure resulted in the functional equivalent test. And Justice Breyer explained it as whether pollutants that arrive at navigable waters after traveling through groundwater are from a point source depends upon how similar to or different from the particular discharge is to a direct discharge. So what does this mean? How do we describe and then implement functional equivalence? So the court did acknowledge that this test could be unavoidably imprecise. And to facilitate implementation by courts and regulators and provide guidance to the regulated community, Justice Breyer clarifies the bounds of functional equivalence. And I've put that wording up on the screen for you because that's going to be a key takeaway from the case. So where a pipe ends a few feet from navigable waters and the pipe emits pollutants that travel those few feet through groundwater, the permitting requirement clearly applies. And at the other end of the spectrum, Justice Breyer advises if the pipe ends 50 miles from navigable waters and emits pollutants that travel with groundwater, mix with other material, and end up in navigable waters only years later, the permitting requirement likely does not apply. He also provided a list of non-exhaustive list, I should say, of factors to consider, and noted among them that time and distance would normally be the most important factors to consider in this decision. Okay, we also had a concurring opinion from Justice Kavanaugh and dissents here as well, and I don't want to leave the opinion without talking about those. I'll look to my co-panelists' faces when I say Justice Kavanaugh's concurrence was a bit of a surprise, maybe. I don't know if it was to anyone else. I think there was some indication in oral argument that he might lean that way, but for me, at least, it certainly wasn't a foregone conclusion. But his concurrence invoked Justice Scalia, both in overt reference over and over again to his opinion in Rapanos, but also in really what was a fervent commitment to textualism, regardless of its outcome. And that was something, looking back at Justice Scalia's opinions, that we see that sometimes he would cast a surprising vote based on really steeped in textualism. And here, this judicial philosophy ends up aligning Justice Kavanaugh with an environmentally friendly result. It seems like a small detail, but I think these nuances are going to be key takeaways from this case that we'll see environmental advocates applying in future cases before the court, particularly because so much of this area of the law ends up being about statutory construction. We also had Justices Thomas and Gorsuch dissenting, arguing the majority's reading was not supported by the statutory text. And Justice Alito dissented separately to emphasize the ruling created a vague standard, inviting arbitrary and inconsistent application. Ultimately, because the Ninth Circuit applied a broader legal standard, the court vacated that judgment and remanded the case for analysis under the functional equivalent test. And I think most people believe that based on the decisions and the factual findings below, that it's very likely the county will be required to get a NPDES permit, and perhaps the parties will finally settle. Not many municipalities finance this much litigation when the outcome at this point at least seems fairly certain. So a few other points I want to raise before leaving the decision itself, the text of the decision. And really two elements stand out that merit attention for law students. Oops, and I must have gone forward one. See if we can go back one slide. Great, thank you. And I think, again, this will be important for those of you who are studying environmental law in law school, and also for some of the fresher environmental attorneys just getting into practice. So the first thing I want to highlight is that although this opinion certainly contained a very deft grammatical rationale by Justice Breyer, it is rooted in statutory purpose. Justice Breyer repeatedly invokes the purposes animating the Clean Water Act in the same breath as its language and structure. And this is a rarity in modern Supreme Court decisions. Most opinions typically focus on plain meaning informed by dictionary definitions, with statutory structure playing a supporting part and statutory purpose often a passing rule at best. So that's one thing that we'll be looking for if we're starting to see a shift maybe in some of those decisions, especially as drafted by Justice Breyer. And the Maui decision also exemplified the current administration's view, which is certainly shared by some on the court, that Chevron, what we call Chevron deference, is outmoded. And we didn't touch upon that yet, so let me just mention briefly that Chevron deference is a judicially created doctrine requiring courts to defer to an administrative agency's reasonable interpretation of a statute it administers if the language at issue is ambiguous. And the Solicitor General here never asked for Chevron deference and argued simply that the court should just follow EPA's interpretive statement from 2019. But none of the justices deferred to EPA here. Instead, the court denounced that position really as opening a loophole allowing easy evasion of the statutory provision's basic purposes. And Justice Thomas's dissent even declares that EPA's reading is not the best one. But at the same time that overt deference is absent here, I do think EPA's long-standing administrative practice still influenced the majority and was quite relevant. I think it likely assuaged some of the federalism concerns and maybe concerns over potential impacts to individual landowners. So the court remarked that when EPA followed the direct hydrologic connection test, there was no unmanageable expansion of the program. So I think the majority took some comfort that over decades, under a legal standard, which is probably pretty similar to functional equivalence, the parade of horribles that petitioner and its amici envisioned for the court just never materialized. So I think administrative manageability, if I can call it that, I think that played a role here in the decision. Okay, so let's talk a little bit about potential impacts, and I'll certainly defer to Laura, who is very much on the ground, going to be implementing this decision for her company. I will certainly defer to her observations on this, but I'll raise a few high-level thoughts on implementation and consequences of the case. So I think we won't know for some time whether Maui is actually going to significantly expand the universe of permittees under the Act, or how much litigation it might spur. Again, we don't know how similar functional equivalence will be to EPA's prior interpretation based on hydrologic connection. But for now, we do have some prescriptions for implementation from Justice Breyer. So he invites EPA to provide specificity through guidance and regulations, and suggests EPA and states could develop general permits. You heard about general permits earlier today. He suggests they could develop general permits for common situations. Further, he notes that functional equivalence will become more precise, of course, as district courts begin to apply the test. And finally, he encourages judges to exercise their discretion when setting penalties under the Act, mindful of when a party could reasonably have thought that a permit was not required. So that's, I won't, harkens back to what you heard Professor Andre speaking about in terms of the penalty factors that a court will apply when looking at a penalty, imposing a penalty under the Act. I do think the use and impact of these prescriptions is going to be delayed. I think we can safely surmise there is neither appetite nor even perhaps time for the Trump administration to promulgate such technical regulations. I think that task will be left to a future and differently constituted EPA. Further, I think we can assume there would be little devotion of government enforcement resources against indirect dischargers in the short term. So In the meantime, I think we might see citizen groups pursue some claims under functional equivalence for certain agricultural, mining, or industrial dischargers. And I think states with delegated NPDES program authority may outline how the factors should be balanced as they issue permits. So maybe on the front lines of implementing this case. And again, you're going to hear more about that from my co-panelist, Laura. Okay, so a few concluding observations here on this case. We can't leave the presentation without acknowledging some of the critiques that the legal community is raising about this opinion, particularly certain sectors of the regulated community. And those critics tend to lament the majority standard as creating insufferable uncertainty and this invitation to litigate. But as you can probably tell from this presentation, I'm not convinced of that result. I think the environmental law community has applied this type of bounded framework for liability before. The example I keep going back to is Justice Stevens' spectrum of arranger liability and the useful product defense that he laid out in Burlington Northern. I live that day in and day out as a trial attorney at ENRD, and many of you on the webinar, Laura is shaking her head, many of you on the webinar may be environmental attorneys who don't just do the Clean Water Act. You may practice under multimedia areas, and so I think this is a skill that environmental attorneys have that we're used to applying this type of standard. The other thing I would say I'm watching for is whether these cases are actually more likely to settle now. A 7-factor scientific test, I think, is very unlikely to be resolved by summary judgment. And so I think a trial on highly technical factors would be quite expensive. So I'll be watching to see how much litigation this actually spurs, or if it ends up, we end up seeing parties settle more frequently under this legal standard. To conclude for today, I'd say ultimately the County of Maui decision came along at a really important moment, and that's what I want the final takeaway here to be. And it really maintains crucial protection for our waters. The majority's decision, which attempts to delineate the scope of federal permitting based on technical determinations, whether pollutants will reach and impact navigable waters, to me is a faithful reading of the Act. It balances Congress's environmental and human health aims while respecting state authority over purely intrastate resources. And those were critical themes you heard from Professors Doremus and Andre earlier. I think perhaps most important, though, is the political and deregulatory climate in which the vote for this decision were cast. The court announced its decision the same week as Trump's EPA finalized a separate regulation limiting federal jurisdiction of the Clean Water Act and excluding groundwater in its entirety. So had the court agreed to the position forwarded by the EPA and county here, the combined impact with this regulation would have been a very severe narrowing of the Act's protection for surface waters. Instead, I think the court signaled very strongly to petitioner, but probably more so to the SG's office, that a constricted reading of the Clean Water Act that they were putting forward just strayed too far from Congress's intent. And in doing so, the court really handed the environmentalists a defensive victory in this case. And while the Maui decision, I do want to make sure I'm clear, this is not going to invalidate the proposed regulation automatically. We could see it providing some additional grounds for legal challenge to that rule. And again, I'll look to my colleague Laura on this panel to talk a little bit more about implementation of this decision and how it might impact what some call the WOTUS rulemaking. Thank you all so much.
Thank you, Sarah. So let me see if I can go ahead and get started. Can y'all hear me okay? There we go. So for those of you who are not familiar with BNSF Railway, we were Burlington Northern. So that's exactly who Sarah was talking about, and that's why I was nodding and smiling, because that is us. So BNSF Railway is one of the largest freight railroads in the US. We operate mainly on the western side of the Mississippi. We cover 28 states, 3 Canadian provinces, and we have about 32,500 miles of track. And in between all that track, we have a number of rail yards, a number of intermodal facilities, and we also serve a number of ports. One interesting fact about BNSF, as you can see on the bottom of the slide, is that BNSF trains can move 1 ton of freight nearly 500 miles on just 1 gallon of diesel fuel. So today I'm going to do a brief overview of general permits with a focus on stormwater permits for industrial and construction activities. I'll touch a little bit upon what EPA is doing there, and then we'll turn to some of the things that BNSF does to comply with the Clean Water Act. And if there's time, we'll get into recent developments on the 401 water quality certification rule, as well as impacts to the industry on all these recent developments that have been happening. So first, what is a general permit? So general permit, as Holly explained, does fall under Empties, and there is either an individual permit, which that's going to apply to a specific facility with a specific discharge, whereas a general permit, just like it sounds, is going to be very general, where it doesn't apply to anybody in particular, but instead it's going to apply to multiple dischargers that are grouped with similar operations and similar types of discharges. And all of those dischargers who fall under that general permit, they are going to have the same effluent limitations and the same requirements. Now, where an individual permit, the applicant actually has to submit the application and go through a process with the permitting agency. For a general permit, typically you submit a notice of intent, or what's called an NOI, to obtain coverage. Once you do that, I wanted to at least note that the permitting authority can come back and say, yeah, you know, we looked at your facility, but we really don't think a general permit should apply here, and we think it really needs to be an individual permit. So the 2 most common stormwater permits, as I mentioned before, are for industrial activities and construction activities. And that's what I'm going to focus on today, not only because they are the most common, but that's really kind of the heart of where BNSF has the Clean Water Act apply to us and how we comply with the Act. So as Holly already showed you the slide, I wanted to mention again, and I'll come back to it when we talk about what EPA is doing. Most of the states are authorized to implement Empties. So that means if you are going to get a general permit, you're going to look to see what the state has issued, and you're going to go to the state agency to get coverage under that general permit. And right now, EPA is the permitting authority for just a handful of states. So an industrial stormwater permit typically is called a multi-sector general permit, or an MSGP for stormwater discharges associated with industrial activity. You may also hear them referred to as an ISGP, or states have a number of different variations on the title there. But what it really comes down to is, what is an industrial activity? So the EPA broadly defines it as any time there is material handling or storage, loading or unloading, equipment maintenance or cleaning, and within the regulations, whether it's state or federal, and sometimes also within the general permit itself, there may be specific SIC codes or categories of facilities that the general permit would apply to. So specifically for BNSF, we are SIC code 4011, so you can see here in subsection 8 that we fall under this provision that governs vehicle maintenance shops, equipment cleaning operations, and airport de-icing operations. The only thing to note here for transportation facilities, it's only those portions of the facility that are involved in those activities that are considered an industrial activity for which a permit is needed. The other larger area for stormwater general permits is from construction. So anytime there is going to be a disturbance of 1 acre or more, or if there is going to be a disturbance of, and again, that disturbance is of soil, if there's going to be a disturbance that is part of a larger common plan, you would need to seek coverage under a construction general permit. And now that permit is going to cover the whole entire time you are constructing your project. And once you meet the conditions to qualify for termination, whether that's your site is permanently stabilized or whether you can transfer control to the next operator, only then can you submit a notice of termination. Now, both the industrial stormwater permits and the construction general permits have very similar common elements. The first one being each require preparation and implementation of a stormwater pollution prevention plan, or SWIP as we call them. And that SWIP is your roadmap of how the general permit is going to be implemented at that specific facility. So both the general permit itself and in more particular sense, the SWIP will have a number of pollution prevention controls stipulated, as well as best management practices, just like the silt fence that you see here in the photo, as well as inspections and certain monitoring, which can include sampling. And it'll also lay out the different triggers for corrective actions and the deadlines for implementing those corrective actions. So EPA recently, I think it was back in March, proposed its latest version of the MSGP. And what happened to get to the point where we're at now with the proposed MSGP is back in 2015, EPA was sued by a number of environmental organizations for its 2015 version of the MSGP, basically saying that the MSGP was not in compliance with the Clean Water Act. So EPA entered into a settlement agreement where it agreed to fund a study by the National Research Council. It also agreed to look to see what other states were doing and to take a look at other corrective actions that should be incorporated into the MSGP, and took all those findings and did revise what had been the standard 2015 MSGP to what is now the proposed version. So the comment period just closed on that on June 1st, and we are expecting the final MSGP to be issued somewhere around October, November, but you know, that has not been confirmed. So where I wanted to bring back what Holly had discussed about the state versus federal relationship, and the fact that most states are authorized to implement NPDES permits, is that even though EPA is going to be the permitting authority in just a handful of states, it's really going to matter what EPA is doing here with their MSGP permit for the states. Because arguably, if the EPA was not in compliance with the Clean Water Act, if the states are not doing what the EPA is going to do in its MSGP, there's the argument there that the states are also not in compliance with the Clean Water Act. So for sure, keep an eye on both what the EPA is doing and what your particular state is doing. So now to the fun part of what BNSF does to comply with the Clean Water Act. There's some major, I can't get into all the details of everything that we do, but I wanted to at least point out some of the more major programs that we implement, of course, are NPDES. And as I mentioned, our industrial activities are fueling and locomotive and equipment washing and cleaning, our maintenance shops, and all those are covered under a general permit. We do have a few individual permits for some of those facilities, but it's typically where it's a larger facility, there's a lot of activities, or where we're generating a lot of water. And then of course, anytime there's track construction or if we're building a new intermodal facility, we seek coverage under construction general permit. One thing I did want to mention that BNSF does is we have our own internal audit program. So we engage with outside consultants who go look at the construction project or go look at the facility to make sure that we have the right permit and to make sure that we are implementing the permit correctly. They look at our SWIPs, they look at our best management practices to make sure that not only are we in compliance with the Clean Water Act, but that we are minimizing any impact to the environment. The other larger area is when we do work over what would be traditionally a navigable waterway or a wetland. And typically it's our bridge construction, as you can see here in the photo. And for that, we would get 404 permits and the 401 water quality certification. And then the last broader group I want us to talk about harkens back to what Abby was explaining to us about spills and the Clean Water Act. So BNSF has a number of facilities that have spill prevention, control, and countermeasure plans or facility response plans. We also have a full-time hazmat team that helps do the drills and exercises that are required under these plans, and that's exactly what's shown in this photo here, where a hazmat team was doing a boom deployment on a river. So in addition to prevention, we have a very robust spill reporting system. As Abby mentioned, that's one place where you can really generate some issues and enforcement issues and penalties. So what BNSF does, we have a system interruption desk where any spill is reported to that desk, which is open 24 hours a day, 7 days a week, 365 days a year. And then of course we have our obligation to notify the appropriate state and federal agencies. And I don't seem to be advancing here. If somebody can get me to the next slide, maybe. Okay, that's actually fine, that's perfect. I'm running out of time here, so nope, you can go back to the other slide. I will at least just mention that the 401 water quality certification rule was just finalized by EPA on the 1st. We are waiting to see when it's published in the Federal Register. As soon as it is, it's going to go into effect in 60 days. So just keep that in the back of your mind as something else to look out for. And the water quality certification rule, we are still evaluating what impact it's going to have on us. So unfortunately that remains to be seen. And kind of around the same thing for the WOTUS definition and the Maui decision, Sara was right on point that it's just too early. There's been so much happening right now with the Clean Water Act that we are still trying to evaluate and get our head around what has been going on. But I think the short version of the story is that there are going to be areas that did not need a permit before, that the Maui factors and the Maui decision is going to come into play. And we're going to have to take a harder look at those to see, do any of those apply to us? But then with the WOTUS definition changes, there's going to be some areas where we either don't need a permit, or when I mentioned earlier about the SBCC plans and facility response plans, those are also based on whether there's a potential to discharge to the waters of the US. Well, if that area is no longer classified as a WOTUS, then we may not need those plans anymore. So BNSF is looking at all of those things right now to, once again, make sure that we not only comply with the Clean Water Act, but to minimize our impact on the environment. So very quickly, because I am running out of time, I wanted to give a bulleted list of things to consider when you are presented with a Clean Water Act issue. So look at the site activities. How much water are you generating? Where is it coming from? Is it going to be a direct discharge or an indirect discharge? What are the types of pollutants? As we heard before, it depends on what you add. In addition, you need to look at, are there temperature changes? Are there pH changes? And then where is that discharge going? Is it a WOTUS? Is it something that's going to fall under Maui? Or sometimes people say, well, let's see if we can send it to the publicly owned treatment works. Then of course we talked about jurisdiction. who's going to have the primary jurisdiction over that issue? Is it going to be the state? Is it going to be the EPA? And then I think the big resounding theme we're getting today is always look at the regulatory and legal developments. So with that, I have a few links that may help to provide a little bit more background about the things that I talked about today. And I hope I've reserved enough time for questions. And with that, I will turn it back over to you, Caitlin.
Thank you so much. We do have some questions, and of course, to our participants, if you have further questions, please enter them using GoTo's question box. So we will start with a question from earlier on, and this question is for Holly, and of course, anyone else, please feel free to chime in, and we'll try and keep our answers a little bit briefer. So Holly, can you describe the recent changes or specifically the ramifications for states to Section 401 by the current administration?
Sure. So I mentioned Section 401, which requires state certification of the water quality standards will be met as a condition of granting a federal permit or license. The Trump administration has just issued a rule that basically tries to narrow the state authority under 401. It sets a hard 1-year limit on how long the states have to look over those applications, and says if they haven't made a decision at the end of that time, it's deemed approved. And there's a history here. There was a FERC case out of the DC Circuit not long ago where the state and the applicant had agreed several times to resubmit the application and essentially extended the timeline. And the rule would say, basically, you can't do that. Even if the applicant is willing, you only have a year. The other thing is that it tries to narrow, and I think it's not clear that this will fly, and I'm sure there's going to be litigation over this one too. The administration is trying to narrow the conditions that states can impose on 401 certifications. There's an old Supreme Court case, PUD number 1 out of Washington, that allowed the states to impose conditions that are not directly water quality conditions. In that case, it was a condition of minimum flow on a hydropower plant. And the new rule tries to say the states can only achieve water quality aims, and they can only achieve those aims to the extent that the discharge itself that allows them to do 401 certification causes the water quality problem. So others may have more to say about that as well.
Thank you. Another participant asks, with County of Maui, how important was it that there were those wells at the end of the discharge, even though the discharge went through the groundwater between the facility and the submarine wells?
Thank you. I think each of the nuances of the facts from the County of Maui played into the court's decision here. Throughout the Hawaiian Islands, and I'm trying to remember the number, but there is an extremely large number of wells just like this throughout the Hawaiian Islands. And I believe it's Justice Alito, perhaps, who cites the number in his dissent. But I do think that's important. I think the fact that there was a discrete point at which you could see the plume of effluent coming up through the ocean really helped move courts on this issue. And so I do think that particular fact was important here. And again, as I sort of intimated in my remarks, I do think it was interesting that the court granted cert on the County of Maui case rather than Kinder Morgan or the Sixth Circuit case. And so the fact pattern was very discrete. And again, not just the wells here, but also the demonstrable environmental harm was very important, not only at the district court level, but if you look at the Supreme Court opinion, I believe they cite brief on behalf of scientists at page 5, something in the very beginning of the opinion. It was very clear how important the role was of the environmental harm and the scientific evidence here.
Thank you. We have an interesting question here. Does the Clean Water Act cover thermal pollution of water, i.e. the dumping of hot or warm water into a stream or river? If not, would thermal pollution be barred if warming of the water would tend to create changes that would impact the water quality? That would be algae blooms, for example.
So I'll take a quick stab at the beginning of that. The answer is yes. The definition of pollutant under the Clean Water Act specifically includes heat.
Perfect, thank you. Our next question is for Professor Colangelo. The participant says that they found it interesting in Maui that the administration asked for the court to look to its interpretive rule as opposed to Chevron defense. Isn't the current administration adverse to guidance such as that which you would see as in an interpretive rule? And how would you reconcile this supposed discrepancy?
Thank you. I'm not sure I quite understood the discrepancy, but I'm going to try to answer the question, and that the person who asked it should feel free to chime in on chat if I don't answer the question. So this administration has taken a stance clearly in multiple times in litigation that they are not going to seek Chevron deference. The briefing does not mention Chevron deference, and this aligns with some of the justices on the court who believe Chevron deference is unconstitutional. So I think that that's where that philosophy comes from. It's an echoing of the judicial philosophy we see from more conservative justices, more conservative members of the judiciary throughout the country. And I think it remains to be seen whether Chevron deference will survive. There are some, and this is not an administrative law panel, but if it were, I think one topic that we could speak about for quite some time is whether Chevron deference is sort of marching to a slow death. There were some recent administrative law cases where that certainly seems to be the case. Justice Roberts, I believe it was the Kaiser case, and I again look to my panelists if that's right. I believe in the Kaiser case, he follows Chevron deference only because of stare decisis, and says we're not going to overrule that today. So, you know, Chevron deference is not as popular as it once was, and you certainly see that reflected in the administration's briefing here by the SG's office. And to get to what I think you're referring to about discrepancy, I think that ended up falling very flat with the court to say, go ahead and follow EPA's interpretive statement. They never asked for Chevron deference and didn't give much in the way of reason to follow that statement. I want to highlight one important thing. Agencies can change their minds about things. That happens all the time, and what some justices would call administrative whiplash. They change their minds about things, and there's no heightened judicial review when an agency changes its mind, but it must engage with the facts and must engage with the prior reasoning and explain that change. And here I think there wasn't that explanation, this reasoned explanation that's required, and I think it fell flat.
Thank you. Another participant asks, are there any other federal environmental laws under which non-point source pollution could potentially be regulated without introducing as many federalism concerns?
Without introducing federalism concerns, I think the answer to that is clearly no, because if the question is, can the feds regulate something that otherwise would be under state control? It doesn't matter what statute you're looking at, that's going to raise the same kinds of concerns. And the real concern, the federalism concerns about non-point source pollution are largely grounded in the idea that regulating non-point source pollution requires regulating land use. And that's an area of traditional state concern, right? So you have to do best management practices rather than best available technology. That means you're changing the way that the land can be used. And typically that's not something the federal government gets much into. And I think whatever statute you use, and certainly CERCLA and RCRA come into play potentially when there's mismanagement of pollutants on land, but you're always going to have those kinds of frictions between state and federal authorities in that context.
Thank you. One of our participants asks, with the recently finalized revisions to EPA Section 401 rule, could one of you please speak a bit about the position expressed therein concerning Chevron defense?
So I'm not sure I understood that question.
Sure. So I think
Chevron
one of the yes, whether Chevron defense has been incorporated to the recently finalized revisions to EPA's Section 401 rule.
I'll take a guess and say that if Maui taught us anything, it's that even though Chevron deference is less popular with the agencies, and particularly under this administration, less popular with the agencies and some of the justices and conservative justices across the country, what we know is that the courts will still look at congressional intent as a controlling, potentially controlling bumper on agency interpretation. And I think people are excited about the Maui opinion because it is so unusually reliant on statutory purpose. And so Chevron, of course, could be applied to any new rule that is challenged and reviewed by the courts. And whether it will survive is one question, but one thing that undoubtedly ought to survive, and Maui gives me hope that it will, is that the overriding purpose of the Clean Water Act will continue to drive, if not agency interpretation, then possibly judicial interpretation of new rules.
Thank you. I think we have time for one. Oh, sorry, go ahead, Holly.
No, go ahead. Go ahead, sorry.
So I think we have time for one more question. A participant asks, what actions can be taken, such as an expansion of sewer systems, to address the control of non-point source pollutants?
I'm sorry, could you repeat that?
Yes, one of our participants asks what actions can be taken, for example, the expansion of sewer systems to address non-point source polluters.
Yeah, so there's a lot that can be done. There are questions about really who should be responsible for doing it. That's the difficult question under the Clean Water Act. So there can be green infrastructure, for example, to reduce runoff from developed areas, to slow runoff and take pollutants out before they get to the waterways. There are ways to design development projects, ways to do different farming practices, those kinds of things that can reduce non-point source pollution. I think the question often comes down to who has to do it and who pays the costs of it.
And I'll add to Holly's point, because I think it's a good one. The first thing that came to my mind was greening. And so to the person who asked this question, if this is a real interest to you, you seem to mention sewer expansion. So really referencing this issue of municipal control. This tends to be a municipal issue with CSO and SSO cases under the Clean Water Act. And so a lot of what we try to address there are issues of I&I, that excess water coming into the system. And so I would suggest that you take a look, if you're really interested in this topic, at some of the consent decrees, the larger consent decrees that the government has filed with municipalities. I would direct you to the Municipal Sewer District of St. Louis case. I worked on that case for several years, and there is a green infrastructure component to that case, but there's lots of these excellent examples around the country, and a lot of times, as in the MSD case that I just referenced, there are also environmental groups that are part of that case. So you can look at different agreements around the country and see how different municipalities are handling this issue, construction of the system originally, and what type of sewer construction you have, whether it's CSOs, SSO violations, that kind of thing. But I think those consent decrees would be chock full of ideas.
All right, thank you so much to our participants for joining us today and for your thoughtful questions. We hope that you'll continue to think about the many complexities of the Clean Water Act. We're so grateful for your participation in ELI's annual summer school series, and we hope to welcome you all back next week for the basics of land use law. I want to extend a huge thank you to our fantastic panel, Holly, Abigail, Sarah, and Laura. You all have contributed so much. Thank you for lending your massive expertise to summer school. Thank you all again, and have a great afternoon.
Thank you, Caitlin.
Thank you.